whether or not we can use information gathered in a non-constitutional or a less than constitutional way, whether we're going to use that for domestic crime. If you believe that, it means that we're carving out in our domestic laws an area where the Constitution doesn't entirely apply. So Section 213 allows the entering of the house in a non-constitutional way, a way that if it were done in a straight-up fashion, the courts would say is illegally gathered information and wouldn't be admissible in court. I think we ought to have a vote. Is the Patriot Act or less than constitutional means of gathering information to be used in domestic court? Here's the other question. If they'll be honest with us, are they using it in any other courts? Are there IRS investigations that begin as terrorist investigations but wind up in IRS court? In some ways, I think yes is the answer. We have now the IRS basing investigations of people, maybe for political purposes, but definitely for the purposes of whether or not individuals are doing transactions in certain ways or whether their records are in a certain way. And because it's done this way, we're not really requiring convictions before we take their stuff. This is a separate but related problem because it has to do with using records to gain entrance to people to then take their stuff without a conviction. And I think that's an important question. Are we innocent until proven guilty? Are we really going to allow the government to take possession of your things, without a conviction? I would think the presumption of innocence is an incredibly important doctrine that we shouldn't so casually dismiss. This is a poll that was commissioned by the ACLU on Monday. And in it, they ask a sample of 300 likely voters between the ages of 18 and 39. They ask them a few questions. Which of the following statements about reauthorizing the Patriot Act do you agree with more? Some people say Congress should modify the Patriot Act to limit government surveillance and protect Americans' privacy. 60% agree. Other people say Congress should preserve the Patriot Act and make no changes because it has been effective in keeping America safe from terrorists and other threats to national security like ISIS or Al-Qaeda. 34%. That's the overall numbers. If you look at it by all parties, Democrat, Independent, and GOP, 58% or greater. In fact, Democrat and Republican are pretty equal, which is interesting. 59% of Democrats, 58% of Republicans think that we've gone too far in the Patriot Act, that Americans' privacy is being disturbed by the Patriot Act. If you look at independents, it's 75% among men that are independent, 65% among women who are independent. If you ask people from this survey, do you find it concerning that the U.S. government is collecting and storing your personal information, like your phone records, emails, bank statements, and other communications? 82% are concerned that the government is storing this information. Over 3/4 of voters found 4 different examples of government spying personally concerning to them. The government accessing personal communications, information or records without a judge's permission, 83%. Using that information for things other than stopping terrorists, such as I mentioned, doing convictions for drugs, were the most compelling examples for voters. They asked whether the government accesses any of your personal communications, information, or records you share with a company without a judge's permission. Tell them whether you're concerned with this issue. 83% were concerned. They ask whether the government uses information collected without a warrant for things other than stopping terrorist attacks. 83% were concerned. They ask whether if the government allows private companies to use public school technology programs to track online activities of school children. 77% were concerned. They ask whether if the government performs instant wiretaps on any phone or other telecommunications device located in the United States. 76% were concerned. From this ACLU study of young people, I believe they were all age 18 to 39. They asked whether or not these were conditions that would lead you to believe that Americans need more protections of their privacy. Local police and the FBI need a warrant issued by an independent judge for a valid reason before they search your home or property without your permission. The same should be true of your email and phone records. 84% agreed. If you ask that question in Washington, it's about a 10 or 15% question. Most people in Washington don't think that your email or your phone records should be protected by needing a warrant. But if you ask most Americans that question, particularly young Americans, should your email or your phone records be protected by a warrant? Most people say yes. The government requires some companies to intentionally include security loopholes in their services to make it easier for law enforcement to access your information. These are these backdoor things where they can insert malware. This makes the government less safe by leaving us vulnerable to terrorists and spies from foreign countries who want to harm the U.S. 81% were concerned with this and thought that we should have more privacy. I think it's clear that the American people are concerned about what we're doing. What isn't yet clear is whether the message has been transmitted to Washington, whether or not there's enough of a majority growing in Washington to actually do something about this. I think the numbers are growing. Over 300 people acknowledged that there was a problem in the House by passing legislation. Now, I have mixed feelings on the legislation. I think that without question, I agree with those who voted for it that bulk collection of records is wrong and that it should end. I've been a little more in the camp, though, that we should just end the bulk collection of records and replace it not with a new program, but with the Constitution. I personally think that we could survive with the Constitution. I think that we could also survive and catch terrorists with the Constitution. In fact, I think we can get more information with the Constitution. I think that valid warrants are much more powerful. A valid warrant allows a great deal more of information, and they're also specific. So once we're doing valid warrants, we're not doing sort of this dragnet. We're not doing sort of this just vacuuming up everything. We're not becoming overwhelmed with a lot of incidental data. What we're doing is we're specifically going to the heart of things. We're specifically going to the core of whether or not we can actually get the people who are attacking us. When we look at the privacy report that we've talked a little bit about, the Privacy and Civil Liberties Oversight Board, that is this bipartisan board that basically said very explicitly to the president that what he was doing is illegal. It does still boggle my mind that the president was told by his own privacy board that it was illegal and he just keeps doing it. It somewhat boggles the mind that he was told by the appellate court that what he's doing is illegal, and yet he just keeps doing it. It's an incredible deflection. It's incredibly disingenuous that the president says, well, we're going to balance liberty and security, and I'm just waiting for Congress to tell me what to do. Well, he didn't wait for Congress to tell him to collect the phone records. In fact, we never did such a thing. Even the people intimately involved with passing the Patriot Act, those who were the co-sponsors and authors of the Patriot Act, have all said they never intended and don't believe the Patriot Act gives any justification for bulk collection of records. So Congress didn't ever authorize the bulk collection of records. Two different commissions that he's put forward, the Privacy and Civil Liberties as well as the Review Commission, have both told him that it's illegal, and yet he keeps going on. I've heard very little questioning of the president or his people about this. I kind of wonder why we don't ask more questions, why we just sort of accept that a program that's said to be illegal by the courts, a program that's said to be illegal by two different independent commissions, why we wouldn't stop it, why the president wouldn't have the wherewithal to stop it. And it disappoints me. The program was actually begun even before the Patriot Act was finalized. We did this for a couple years just simply by presidential edict. This is another concerning development in our country, is that more and more your government is run by executive edict, by executive order. Thousands and thousands of executive orders. In the 1950s, we had a discussion of executive orders. I think it's the only time it's gone to the Supreme Court, the Youngstown Steel case. And in the Youngstown Steel case, the court came down and said that there are three different kinds of executive orders. There are executive orders that are clearly in furtherance of legislative action, and those are perfectly legal. There are executive orders that are debatable, whether they further legislative action or not. But then there are some executive orders that are clearly in defiance of what the legislature has done, and these are clearly illegal, and the Supreme Court struck down what Truman had done. I think we need to revisit that debate, because what's happening in our country, and it may well be the biggest problem in the country, is part of what's going on with this bulk collection, but really it's part of a bigger problem. The bigger problem is that power has drifted away from Congress or has been abdicated and given up. We gave the power to the presidency, and we didn't do it just in one fell swoop. It wasn't just Republicans, it wasn't just Democrats. It was a little bit of both, and it's been going on for probably over 100 years now. I think it accelerated in the era of Wilson, but over decades it's gotten bigger and bigger and bigger. Under the New Deal, the executive branch grew an alarming amount, but more recently it continues to grow by leaps and bounds. It may well be the number one issue that we face as a country is that we've had what some have described as a collapse in the separation of powers. Madison talked about that each branch would have ambition to protect their own power. So we would pit ambition against ambition, and that each would jealously guard their power, and as such, power wouldn't grow, power would be checked. But power has grown. It's grown alarmingly so, and mostly grown and gravitated to the executive branch. So in the short time that I've been here, I've seen that in many ways, the least of our bureaucrats are more powerful, probably in some ways, than the greatest of our legislators. So the most powerful of our legislators are somewhat of less power than bureaucrats. Almost every constituent that comes to talk to me from Kentucky that has a problem with government, as we explore the problem and explore the solution, we discover that Congress didn't pass their problem. Congress didn't write the rule that is beleaguering them. Congress didn't inflict the punishment that is making it difficult for them to run their business. It was done by an unelected bureaucrat. This has grown, and sometimes it's grown from even when we had well intentions, when we tried to do the right thing, but it turned out wrong. And probably that's really the story of Washington as well. Take even like the Clean Water Act. Clean Water Act, I support. I would have voted for it. 1974 says you can't discharge pollutants into a navigable stream. Well, I agree with that. The problem is that over about a 40-year period, we've come to define dirt as a pollutant, and my backyard is a navigable stream. And so once again, we take our eye off the prize. What are the things that we really ought to have the government involved with? Big bodies of water between the states, rivers, lakes, oceans, air. There is a role for the government to be involved. But because we've got people abusing the rights of private property owners and saying, if you put dirt in your backyard, we'll put you in jail, it's become sort of to the point of craziness. But it's all executive branch overreach. There was a case that went to the Supreme Court a few years ago in Idaho. And the couple lived near a lake, but about a mile from a lake. They didn't live on the lake. It was on an incline, and there were houses on both sides of their property. So they bought their property and started doing what everybody else did, backhoeing and creating a footprint and filling it and putting down footers. The EPA showed up and said that you're destroying a wetland, and we're going to fine you $37,000 a day. Well, they were kind of like, well, I thought if it were a wetland, there would be water, or standing water, or it would look like the Everglades, or there would be some sort of evidence that it's wetlands. Well, the EPA said, yeah, there is evidence. If any one of 300 different species of plant grows in your backyard, we can define it as a wetlands. We can take leaves, and if we flip the leaves over and they're black on the bottom, and it indicates there's moisture under the leaves, and you could be a wetlands. But this all came out of crazy executive overreach. We did not do any of that. Congress did not do one iota of this expansion. It was done some by these law courts, these EPA courts, but it was done a lot by executive definition of what a wetlands is. In the early 1990s, under a Republican president, we redefined a wetlands. They commissioned a book, I don't know, 50-page book, 200-page book, and they just redefined what a wetlands was. And by redefining what a wetlands was, we doubled the amount of wetlands in the country overnight. Not by preserving land, but by redefining a lot of land that it really is not a wetland. We now are connecting all through the waters of the U.S. We're connecting everybody to the ocean somehow and saying that every bit of land is somehow connected to navigable water. I was talking to one of the senators from Idaho a year or so ago, and I liked what he told me. He told me, in Idaho, we've got a very precise definition of what a navigable stream is. You put a log in of 2-inch diameter, and it has to float 100 feet in a certain period of time. And I just love the definition of it because, yeah, that sounds like a stream that's probably moving and there's some water in it. But we now say a crevice in the side of the mountain is that if when it rains, water goes over there, is a stream. But as a consequence, we're shutting down America. People complain about jobs, but they're all for these regulations, and then they complain that they don't have a job. One gentleman decided that he was going to put dirt on his land in southern Mississippi, and it was what he considered to be uplands. There were trees growing on it, so usually trees, are not really a typical feature of wetlands. His daughter was about, I think she was 43 at the time, and he was 70. And they were going to develop the lots and sell the lots. And so he dumped some dirt there. The EPA then got involved, and they convicted him using the RICO statutes. This is what you're supposed to get gangsters with and drug dealers with the RICO. It's conspiracy. So they got him for conspiracy to violate the Clean Water Act by putting clean dirt on his own land where there was no water to begin with. He was given 10 years in prison. He just got out of prison about a month ago. He's now 80 years old. That's what's happening in America. And so you wonder why some of us are worried about our records being snatched up. We're worried that our own government's run amok, that our own government's out of control, and that our own government's not really paying attention to us. And to put a 70-year-old man in prison for 10 years for putting clean dirt on his own land, the person who did that ought to go to jail. In fact, they ought to be put in a stockade and publicly flogged and then made to pay penance for a decade for doing something so stupid. But the thing is that this is going on. guy named John Potsky was a Hungarian immigrant, came here, loved our country like so many immigrants. He came here from communism, and he loved being in our country, and he worked hard, and he had a little, like a mechanic shop, I think, in Morristown, New Jersey. Wasn't in the greatest part of town. It was a commercial part of town. It was all these commercial buildings. Across the street from him was a dump. It did flood on occasion, but the reason it flooded was the ditches were full of 7,000 tires. People just throwing all kinds of crap there. There was all kinds of rotted out automobiles. It was a junkyard. So they'd thrown all this stuff out there. He bought the land pretty cheap because it was a junkyard, and he decided to clean it up. He picked up 7,000 tires. He picked up all the rusted automobiles, and lo and behold, when you clean the drainage ditches, it no longer flooded. But he started putting some dirt on there, and the government said he was breaking the law, that he was once again contaminating wetlands. He was a Hungarian, and he didn't like to be told what to do, and I can understand the sentiment, so he just kept putting the dirt on there, and he decided to do it at night, and they caught him because they spent, I don't know, $250,000 on cameras and surveillance to catch a guy putting dirt on his own land. He was bankrupted. They put him in jail for 3 years. They fined him $200 and something thousand. They wiped him out such that he couldn't even pay the taxes. They broke his spirit. I've met his daughter. It's just a tragic case. So you wonder why some of us are worried about the government having all of our records. I talked earlier about what happened in Westchester, and I think this is an appalling thing that should make you concerned about having records. In Westchester, I think that's where the Clintons live. But anyway, they decided they would reveal all the gun records. And so in Westchester, they revealed whether you had a gun or didn't have a gun and where you lived. And it's like, can you imagine how that might be a problem? Let's say you're a wife that's been beaten by your ex-husband and you live in fear of him, and you either have a gun or don't have a gun. Either way, you don't want your ex-husband to know where you live. And particularly if you don't have a gun, you don't want your ex-husband to know that beat you that you don't have a gun. Think if you're a prosecutor or a judge. They get threatened by the people they put in jail. Would you want your name in the paper with your address and that you have a gun or don't have a gun? So you can see how privacy is kind of a big deal. Privacy can mean life and death in that kind of situation. I think we ought to be more cognizant of what a big deal this is and what a big deal the Bill of Rights is. We shouldn't be, I think, so flippant that we're like, oh yeah, whatever. Let's just, we got to be safe. And, if maybe we catch a terrorist, maybe we don't, but we've got to do this. And we just have to give up some of our freedom to be secure. It turns out, though, when you look at the objective evidence, that it doesn't appear that we are more safe. It appears that when they've alleged that we're safer, what has happened is it doesn't look like we've gotten any unique intelligence from these things. I think that probably there's nothing more important than discussing the Bill of Rights and talking about our civil liberties. I think that we need to have an adequate debate. It's supposed to be what the Senate was famous about. My hope is that from drawing some attention to this issue today, that we'll get an agreement. And that's the agreement we're going to ask for. We're going to ask for an agreement from both parties to allow amendments to the Patriot Act. We're going to ask, and we could start anytime they're ready. If somebody wants to send a message to the leadership, if they're ready to come out and allow a debate and allow amendments on the Patriot Act, or a promise to do this before the expiration, we could probably get something moving. I think the American people are ready for that debate. I think the American people, look at the statistics, particularly among young people. It's a 70 to 80% issue where young people are saying, for goodness sakes, we don't want our records scooped up, vacuumed up by the government without any suspicion. I think it's also that young people get this more than others because they're used to their records being digital. They're used to their records being on their phone. They're very aware that their records are stored on a server somewhere. And you've grown to expect privacy. Now, some say, oh, that's crazy. Young people share their information all the time. Well, you do and you don't. You share your information. I share my information when I buy things online, but I'm sharing it through an agreement. The people I share it with, the companies that then market other things to me, have agreed through a privacy agreement not to share my information, not to sell my information. I'm to be anonymous, but they will market to me, but they've promised to keep me anonymous. We're comforted by the fact that we have a privacy agreement, and that if millions of people sued them, they couldn't get away with revealing our information. What I don't like about some of the different things that we're doing, and this includes the USA Freedom Act, is that we give liability protection. When we give liability protection, I think it's an invitation to say, you know what, your privacy agreement really isn't that important, and if you breach it, nobody's allowed to sue you. And so I think that that's something we ought to be very careful with. And if we do end up having a debate on this, and we do end up having amendments on this, that we consider taking out the liability protection. I think also the most important thing is that if we decide that bulk collection is wrong, we need to understand how you get bulk collection. You get bulk collection because you have a non-specific warrant. You don't have an individualized warrant, you have a general warrant. This is what we've been fighting since the time of John Wilkes in 1760 in England, through James Otis in the 1760s here, through John Adams. The debate has always been about, and the thing that we found most egregious, the thing that we found most objectionable, was the idea that a warrant for your information wouldn't have your name on it. It wouldn't be individualized, or that it wouldn't be without suspicion, or that it would occur without a judge's warrant. It really was one of the things that annoyed us more than anything else. One of the things that, Adams said was the spark of our war for independence was just the sheer gall we had of British soldiers coming into our house without a warrant. Because most of your records are in your house, we don't see basically the physical and abrupt entry into your house anymore. But it happens nonetheless. It happens in just less of a physical way because your records are virtual now. But how we let people come into our house is pretty important. On the issue of warrants, this isn't specific to the PATRIOT Act, but it's a related issue. And the issue is whether or not we should allow people to come into our house in the middle of the night with what's called a no-knock raid. The sneak and peek, they come in and leave. The no-knock raid, you know they're there when they come. But the problem is that people are being woken up in the middle of the night and they're grabbing their gun by their bedside. If they're in a high-crime neighborhood, they have a gun by their bedside, and they're sometimes shooting the police. Most of these are looking for drugs. And I hate drugs about as much as anybody. I've seen addiction to drugs. I've worked with people as a physician, and I know what it's like. But the thing is that barging through doors in the middle of the night leads to accidents in both ways. Police get shot. Police accidentally shoot the victim sometimes. In Modesto, in I think it was 2002, they burst into a home, 1 or 2 in the morning, yelled and screamed, "Everybody get on the ground, everybody get on the ground." There was an 11-year-old kid. He got on the ground, and the officer's shotgun accidentally discharged. And it was an accident, but it didn't help the kid. He died. And it's like, the thing is that, do we really need that? Do we need to come in the middle of the night looking for marijuana or any kind of drug? Couldn't we come in the daytime and knock on the door and say we've got a warrant? Now, I know police work is not without risk, and people do shoot back at them. So I understand where they're coming from and wanting to protect them and to be safe, and I want to protect the police. But I actually think it protects the police more if we go in the way we do with traditional warrants and not with unannounced warrants. Now, of course, there are different circumstances or exigencies. There are times when police go in without any warrant at all. There's something imminent going on or some threat of a dangerous situation inside, police go in. But I think for the most part, we're better off if we do things and do them in the traditional way with warrants. When we talk about how warrants have changed, one of the changes is that with the standard for what the warrant is issued with, even if it were individualized, if it says that you only have to say they're relevant to an investigation, that's a big step down from probable cause. People have defined probable cause over time in different ways. This is from Ballantyne's Law Dictionary. A common definition of probable cause is a reasonable amount of suspicion supported by circumstances sufficiently strong to justify a prudent and cautious person's belief that certain facts are probably true. Now, some lawyer must have written that, but you can kind of get a little bit of an understanding that we're supposed to go through some kind of thought process, and there's supposed to be evidence of suspicion. Now, it's not the standard of proving guilt, proving beyond preponderance of the facts or beyond any kind of doubt. But the thing is it is a standard, and it's a standard that we've had for a long time. The Oxford Companion to the American Law defines probable cause as information sufficient to warrant a prudent person's belief that evidence of a crime or contraband would be found in a search. Probable cause is a stronger standard of evidence than a reasonable suspicion, but it's weaker than that we require for a criminal conviction. Even hearsay can support probable cause if it's from a reliable source or supported by other evidence, which is kind of interesting because people are so worried about getting a warrant, but even a warrant can be supported by someone making an accusation. It's not perfect. In fact, there are some people that complain warrants are too easy to get. But the thing is that there's no evidence that it's really overly hard to get a warrant. That if we went back to the Constitution, I had this debate years ago with one of the last time it came up for renewal, and I was walking along with one of the other senators who supported the PATRIOT Act, and he acted as if, well, you know what, if it expires at midnight, what will we do? And, my response was maybe we could live with the Constitution at least for a while. We did for hundreds of years, Is there anything so unique about the times we live in that we couldn't still live under the Constitution? The Fourth Amendment has its origins in English common law in the saying that a man's home is his castle. This is the idea that someone has the right to defend their castle or home from invasion from the government. Based on the castle doctrine in the 1600s, landowners first were accorded legal protection from casual searches from government. So some of the famous cases are actually in the 1760s, but even at least 100 years in advance of that, they were beginning to develop protections for people from the government. And it's interesting to realize that this is not a new phenomenon where we're talking about protecting ourselves from government. We protect ourselves, and government helps us protect ourselves from others who might be violent against us. But we've always, for hundreds and hundreds of years, been aware that government does bad things too, and that if you don't control, if you don't ration the amount of power that you give to government, that you can get to a point where the great abuse comes from government itself. So they began to use warrants, but in England, the debate quickly developed over whether a general warrant was adequate or a specific warrant. This is where John Wilkes comes in. This is where James Otis comes in. One of the debates over the separation of powers that we have, and this is pretty commonly going on, although I think the people who believe in unlimited inherent powers are probably in the majority in Washington. But there's a debate over what people call Article 2 powers. So the Article 2 is where the executive is given powers under the Constitution, but there are people who sort of believe in this unlimited nature, that there really is nothing really that restrains. In fact, some have said, even in the debate over this, that the Executive Order 12333 that is involved in some of this records production, they say that it's really none of our business because it's Article 2. It's part of the inherent powers of the president to, in times of war, times of conflict, do whatever they need to do. Well, I think that's a dangerous supposition, to think that really that there are times when there are no checks and balances. I personally think that it was probably one of the most genius things that we got out of our founding fathers was the checks and balances and the division of power. Montesquieu was one of the philosophers that the founding fathers looked to, and some say, you know, when we were setting up the separation of powers, that he was probably where we got the example. But Montesquieu said that when the executive begins to legislate, that a form of tyranny will ensue, because you've allowed too much power to gravitate to one body and you haven't divided the power. The division of power was one of the, if not the most important, one of the most important things we got from our founding fathers. But we're having this collapse of the separation of powers. It's getting to be where there's an ancillary body, which is Congress, and then there's the executive branch, the behemoth, the Leviathan. The executive branch is so large that really the most important laws in the land are being written by bureaucrats that no one elects and no one can unelect. In an average year, there are over 200 regulations that will cost the economy $100 million apiece. We don't vote on any of them. You vote indirectly for the president, but I think that's so indirect that it's a real problem. And I think what we have now is we have an executive branch that legislates. And so the collapse of the separation of powers is it's a collapse of the equilibrium. And this equilibrium is what kept power in check. And when I think who's to blame for this, it isn't one party, it's really both parties. When we have a Republican in office, Republicans tend to forgive a Republican president and give them more power. When we have a Democrat in office, the Democrats tend to forgive a Democrat and give the Democrat more power. A more honest sort of approach to this, or a more, I think, statesman-like approach to this, would be that if we were able to have both parties stand up as a body, and if there were pride in the institution of Congress, pride such that we were jealous of our power, that we were pitting our ambition to keep our power against the ambition of the president, regardless of the president's party affiliation, then we might have a chance. A lot of the things about collection of bulk data were not known for years and years, but have been going on for a long time. One of the things that I found most troubling in the John Napier tie op-ed was that he said, and he was giving a speech, and he said, well, the good news is that if the American people are upset, if they're upset about things, intelligence activities, and they think it's an overreach, that they have every opportunity to use the democratic process to change things. This went through the White House censor, and the White House censor, counsel, advisor, boss, decided that they needed to take that out of his speech because they didn't want to imply really that intelligence activities could be changed through democratic action. Because they took the opinion, apparently, that the inherent powers of Article 2 are not subject to democratic action. So when I think of the people who say that the inherent powers are unlimited and that the president has these powers that are not to be checked by Congress, I don't think of a presidency. I think of a different word, and it's not president. So I'm very concerned about whether or not we're going to let this go on. There are some other side effects that come from this. As you allow the executive branch unlimited power, as you allow the bureaucracy to grow, a consequence or a side effect has been that the debt has grown to alarming portions. We borrow about $1 million a minute. We have an $18 trillion debt. And as the debt has grown larger, the executive branch has grown bigger, your congressmen and women have grown more ancillary and more peripheral to the entire process. But I'm one who believes that there are limits. I think there is a limit to how much debt we can incur and how rapidly we can incur it. I think already we see sort of an anchor or a burden, an effect on the economy that pulls us down and causes growth to be less vibrant. Some say 1 million jobs a year, are being prevented from being created because of this. So I think that if we're not careful, that this collapse of the separation of powers, this collapse of equilibrium, as we let this get away from us, that really we're also getting away from us the control over our future. We're letting the power accumulate in such a rapid fashion that if you want to see how much power is accumulating, you could almost make the analogy of looking at the debt clock. If you go to debtclock.org and just watch the debt spiraling out of control, as the debt grows larger and larger, I think you basically are seeing a corresponding diminishment of your freedom. And it is of concern. It's of concern how rapidly this is happening. There's sort of, I think, two philosophic reasons why we should be concerned about power. One, that power corrupts. But really more basic than that is that as power grows, there has to be a corresponding loss of your freedom. I call this sort of the liberty argument for minimizing government. Thomas Paine sort of made this argument. Thomas Paine said that government is a necessary evil. What do you mean by that? I think what he meant by that is that you need government. We need government for a stabilizing force. There are things that government needs to do. But it's a necessary evil because you have to give up your liberty to have some government. How do you give up your liberty? You give up some of what you earn. Your liberty is who you are. The liberty is what you produce with your hands. And the liberty is what people will pay you to do things with your hands, what you do and produce. That's your income, that's your liberty. So if we have 100% taxation, I would say you have no liberty. You're essentially a slave to the state. If you have 50%, you're only half slave, half free. But the thing is that the smaller your government, the lower your taxation, the more free you are. But it's an argument for, if you're concerned about freedom, you'd want as small a government as you possibly could have that still did the things that you think are necessary. The other argument I like for why you should keep your government small is what I call the efficiency argument. The efficiency argument, I think, was best expounded by Milton Friedman, who said that nobody spends somebody else's money as wisely as their own. And there's sort of a truism to that, and you think about it in your own life. If I ask you for $1,000 to invest in a business enterprise, you'll think, how long did it take me to earn $1,000? You'll think, I had to pay taxes, I had to save, I had to pay all my expenses to get this $1,000. And you'll think how much you prize that, and you won't make the decision in an easy fashion. You'll make your decision not perfectly, but if you compare your decision spending your money to a politician spending the money, it's just bound to be a wiser decision. It's a more heart-wrenching decision, and it ends up typically probably being a better decision. Because your politicians, if you ask a politician for $1 million, that might be equivalent to 1,000, or it might not mean anything to them. You might ask them for $10 billion. I mean, think about it this way. We gave $500 million to one of the richest guys in our country to build something that nobody seemed to want. And he lost all of the money. And you think to yourself, do you think the person in the Department of Energy that gave $500 million to one of the richest guys in the country to build something we didn't want feels bad or doesn't sleep well at night? No, I think they gave that person the money because that person was a big contributor. They were an activist for their candidate, so when they got in power, they used the Department of Energy as their own personal piggy bank to pass out loans to their friends. But nobody feels bad about the fact that they lost the money because it wasn't their money. So it's the efficiency argument for why you should think that government should be small. Before the Patriot Act, there was something called stellar wind. This was a secret also, and we didn't learn about this for many years, but this was started immediately after 9/11 and was revealed by Thomas Tam at the New York Times in 2008. But it basically was a prelude to the bulk collection that we're having now. So the amazing thing about bulk collection is none of this is new. It's been going on now for 14 or 15 years. It doesn't make it any less objectionable, but it's not new. We've now had bulk collection under two different administrations. One administration got a great deal of grief for this, and then the next party ran and said, we're going to change these things and we're going to do things differently, and they did them the same or more so. So there really hadn't been any changed, and that's why some people, I guess, are concerned about whether or not we truly get change. The program's activities in stellar wind involve data mining of large databases of communications of American citizens, including emails, telephone conversations, financial transactions, and internet activity. William Binney, a retired leader within the NSA, became a whistleblower because he believed these programs to be unconstitutional. The intelligence community also was able to obtain from the Treasury Department suspicious activity reports. So we're back to these banking reports that are issued also. If we decide to fix bulk records and try to do something about this, I think, injustice, the main thing is we should be aware that this isn't the only program. There's probably a dozen programs. There's probably another dozen we haven't even heard of that they won't tell any of us about. And realize that they're not asking Congress for permission. They are doing whatever they want. We did not give them permission under the Patriot Act to do bulk collection of phone records. They are doing it with no authority or inherent authority or some other authority because the courts have already told them that there is no authority under the Patriot Act. There's also no common sense logic that could explain, no common sense logic that could say that there's a relevancy to all the data of every American. When stellar wind came about, there were internal disputes within the Justice Department about the legality of the program because the data was being collected for large numbers of people, not just the subjects of FISA warrants. The stellar wind cases were referred to by FBI agents as pizza cases because many seemingly suspicious cases turned out to be food takeout orders. Imagine also that if we're looking for interconnecting spots, that a lot of people order pizza. According to Mueller, approximately 99% of the cases led nowhere. Nevertheless, internal counsel for the administration said that because the nation had been thrust into an armed conflict by a foreign attack, the president has determined in his role as commander-in-chief that it is essential for defense against a further attack to use these wiretapping capabilities within the United States. He has inherent constitutional authority to order warrantless wiretapping. The memo goes one step further. It says that the president has inherent constitutional authority to order warrantless wiretapping. We're talking about warrantless. We're not talking about any kind of subpoena here. Warrantless wiretapping. And it goes on, here's the conclusion. An authority that Congress cannot curtail. So if we really believe that bulk collection is wrong And if we really believe that we need to be a check and balance on the president, we should just be getting started with reining him in on bulk collection, because the president, this was the previous administration, but the president says that these authorities they're using cannot be curtailed by Congress. If you talk about a presidency that has powers that are not checked by Congress, I don't think we're talking about a presidency here. There's another name for that kind of leader, but it's not president. The argument here is astounding. The argument here is that they can collect anything they want without a warrant because the president has inherent constitutional authority to order warrantless wiretapping, an authority that Congress cannot curtail. I think that's alarming. A few years later, though, the Office of Legal Counsel came back, this is also from the administration, and concluded that at least the email program was not legal. And then acting Attorney General James Comey refused to reauthorize it. William Binney, a former NSA codebreaker that we've talked about, who is a whistleblower, talked about some of the activities of the NSA. He said they have highly secured rooms that tap into major switches and satellite communications at both AT&T and Verizon. The article, I believe this was New York Times, suggested that supposedly dispatched stellar wind, supposedly they were no longer doing this, continues as an active program. This conclusion was supported by the exposure of room 641A in AT&T's operations center in San Francisco in 2006. It gets back to the trust factor. The director of national intelligence said they weren't collecting any bulk data, but he wasn't telling the truth. They tell us stellar wind ended some back in 2005, 2006, but then we find a room at AT&T that's still hooked up directly to the NSA. I would like to see the phone companies be better defenders of our privacy, but with the PATRIOT Act, we gave them immunity. Even if there were some individuals in the phone companies that cared about your privacy and thought that your phone conversations should be protected, why do it? You can't sue them. If you have a privacy agreement with your phone company, they don't care. Nobody can sue them. It has no protection. You have no standing in court to protect yourself. It's one of the problems of the USA Freedom Act is that we're giving liability protection once again to the phone companies for something new. One question I would ask, if there was anybody that would actually tell you the answer, would be, if we already gave them liability protection under the PATRIOT Act, why are they getting it again under the USA Freedom Act, unless we're asking them to do something new that they didn't have permission for? The other problem with the USA Freedom Act is, if you think bulk collection is wrong, why do they need new authorities? Why are we giving them some kind of new authority? Are we restricting their authority in 215, Section 215 of the PATRIOT Act on one hand, and then expanding it on another? I think when people are dishonest with you, you're right to be doubtful, and you're right to try to circumscribe and to put their power in a box such that you can watch them and make sure that they're honest. In June of 2013, the Washington Post and the Guardian published an offer from the Office of the Inspector General draft report dated March 2009 that detailed the stellar wind program. So still in 2009, there was evidence that stellar wind was still going on. And realized stellar wind's not what we're talking about. Stellar wind would be other bits of information that are being collected beyond your phone records. So I think if we had someone here, or if we had somebody who would honestly tell us, I'd sure like to know, do they absorb and collect all of our credit card information? I have a feeling it probably is done. I don't know, and I've not been told, so I'm not revealing a secret, but I guess it is done. I'm guessing all of your records are collected. Because the thing is we have the audacity of the executive branch saying that they have inherent constitutional authority to do anything they want, to order warrantless wiretapping. According to the executive branch, they have an authority that Congress cannot curtail. That doesn't sound like the office of the presidency to me. It sounds like the office of a governmental official that you have no control over. It sounds inconsistent or antithetical to really a constitutional republic. How can you have a presidency that has unlimited power? That's what they're telling you. Now, they're telling you it's in the service of good. We're going to catch terrorists, we're going to do good things, and we're going to look at all of your information, but we're never going to abuse your privacy. During September 2014, the New York Times asserted questions persist after the release of a newly declassified version of a legal memo from the NSA Stellar Wind program, a set of warrantless surveillance and data collection activities secretly authorized after 2001. The article addressed the release of newly declassified version of the 2004 memo. Note was made that the bulk program, telephone, internet, email surveillance of American citizens remained secret until the revelations by Edward Snowden. In that to date, significant portions of the memo remain redacted in the newly released version as well, that doubts and questions about its legality continue to persist. When we go back to the Privacy and Civil Liberties Oversight Board, as they get closer to their conclusion, they talk about, once again, the idea that you're only hearing one side. And I think no matter how honest, no matter how patriotic people are, one side just won't do it. You can't find the whole truth when only the government presents their position. The Civil Liberties Privacy Board says that the proceedings, with only one side being presented, raise concerns that the court does not take adequate account of positions other than those of the government. They recommended the creation of a panel of private attorneys, special advocates, who can be brought into cases involving novel and significant issues by FISA court judges. I think this would be a step in the right direction, but I think also that what we need to do is we really probably should give you the ability to have your own attorney. If this is a court proceeding, I think having your own attorney, so you really have somebody who works for you, who is your advocate. But a special advocate would be better than what we have. The board goes on to conclude, transparency is one of the foundations of democratic governance. Our constitutional system of government relies upon the participation of an informed electorate. This, in turn, requires public access to information about the activities of the government. Transparency supports accountability. I couldn't agree more. It's even more important when you talk about the intelligence agency because of the extraordinary power we give to these people. the extraordinary power we give them to invade our privacy and to have tools to invade our privacy, we have to trust them. So there needs to be a degree of transparency. The transparency doesn't have to involve state secrets. It doesn't have to involve code or names, but the transparency needs to be involved what they're doing. The thing is that